Thank you, Las Concordant Chair in time, with permission of the House, with Deputy Curran and Deputy John Brazza. Firstly, I want to compliment Deputy Ellis on using Sinn Féin's private members' time to bring forward this bill in his attempt to try and address the current lacuna in the law. Now, Deputy Ellis referred to the urgency of this, and he also referred to the fact that they introduced it in the Dáil a year and a half ago, and it has taken them 18 months to use their private members' business to bring it to the floor of the Dáil this evening. I know my colleague Deputy John Curran raised this by way of a parliamentary question to Minister Ross in December 2016, and at that time in his reply Minister Ross said the Gardaí had sufficient powers to deal with this menace. Now, we know that that's not to be the case, and I suppose the delay in Minister Ross coming to the realisation that there needs to be a change in this law has resulted in the continuous use of these quads illegally, and has resulted in people terrorising people in public places, and has resulted often in serious injury. Now, I know my colleague Councillor Paul McAuliffe has raised this issue on a number of occasions at the JPC, and he too would like to see legislation brought in to address this issue. But our job is to ensure that we enact robust legislation. Our job is to ensure that we enact legislation that is not open to challenge and that will not undermine any other legislation. And I know Sinn Féin are looking over to see what we're doing, and what I would say to Sinn Féin is we know that they're late comers to the law of the land, but the simple fact of the matter is that we must ensure that any legislation that is passed here is robust and accurate. And not only will this legislation, if it's enacted, be open to challenge, but it has the capacity to render all other traffic legislation vulnerable to legal challenge and impede enforcement of the law of the land. And I don't think anyone wants to see that happen. Essentially, a number of legal challenges have been brought against prosecutions of road traffic offences on the basis of whether the alleged offence took place in a private place. Over the years, the definition of public place in the context of road traffic law has been strengthened as a result of these cases, and the court's understanding has been deeply enriched. Amending the definition of public place, as this Act does, would potentially undo much of the work that has been done. The current definition of public place in the road traffic legislation is any public road and any street, road or other place to which the public have access with vehicles, whether as a right or by permission, and whether subject or free of charge. As I said, this private member's bill proposes to amend Section 41 of the Road Traffic Act 1994 concerning the detention of vehicles to expand the definition of public place by adding the following meaning: any outdoor area, including public parks, to which members of the public have access or are permitted to have access, whether as a right or a trespasser or otherwise, and which is used for public and recreational purposes. Now, earlier this year, Minister Ross, it took him months, if not years, to bring forward an amendment to the road traffic laws. And as I said at the outset, going back 18 months ago, he felt there was no need to address this issue. There is quite a clear need to address this issue. In fact, in December 2017, the Law Society of Ireland called on the government to tear up and start again road traffic laws. Road traffic acts in Ireland are needlessly complex and confusing and need urgent consolidation and simplification. There is a consensus within the legal profession that the road traffic legislation is needlessly complex and confusing, as they were described by the late Supreme Court Justice Adrian Hardiman. There are 22 different acts on the books that deal with road traffic laws, with hundreds of other related pieces of legislation that require consideration when judges are adjudicating on road law violations. David Staunton, the barrister and author of the book Drunken Driving, has argued that we need to tear up the current system and start again. That is a conclusion that our profession would support, he said. Such needless complexity in the legislation undermines public confidence in the justice system. So, Minister, what I would ask here today is, number one, can you give a commitment? You have said, as we do on this side of the House, support the principle of the bill. We want to see the principle that is, as I've no doubt Deputy Ellis is sincere and genuine about. We want to see that addressed. Can you give a commitment? And I said this to Deputy Ellis earlier on, if he was prepared to withdraw this bill for a period of 2 months and enable the Department of Justice work with the Deputy, and indeed work with other deputies in the House, to bring forward something that is not going to leave other pieces of the road traffic legislation open to challenge. That I think that might be a way that we can move this forward. And can I also ask, Minister Ross, because you said in your statement and your contribution to the Dáil a few moments ago that road safety is a paramount concern to you in your role as Minister for Transport. And to be fair, it is one of the only pieces of legislation that you have been able to bring forward in the Dáil in your 2-year tenure as Minister for Transport. Can I ask, when does the Minister and the Government intend to follow on the advice of the Law Society and to begin working as a matter of priority to address the complexities in relation to the road traffic legislation, to consolidate the road traffic legislation, to ensure that we have road traffic legislation that is fit for purpose, to ensure that we have road traffic legislation that is not open to challenge, and to ensure that we have road traffic legislation that will minimise and reduce the number of serious accidents and the number of fatalities on our road. Of course, the other recommendation that the Law Society made in December of last year to the Government is the need to increase the number of judges because of the backlog in getting cases that need to be addressed by the judicial system. And we know that Minister Ross's only intervention in relation to appointment of judges is the prevention of the appointment of judges and the hold up in relation to the appointment of judges. And again, if you want to see repeat offenders, if you want to see people who have been convicted of road traffic legislation put off the road, we need to see more judges in the district court that can hear these cases and ensure that people who are offenders on the road suspended and put off the road. But I'll finish up by saying I know Deputy Curran has raised this issue before, I know Councillor McAuliffe has raised the issue before, and I know my colleague and Deputy Party Leader Dara Calleary has produced a bill in relation to this issue. There is cross-party support in relation to ensuring that something can be achieved in regarding to this menace on our roads and in public spaces. But we have to do it, and we have to be conscious that we do it right, that it's fit for purpose, and that it's not open to legal challenge. And I would ask Sinn Féin to withdraw the bill, to work with us in Fianna Fáil, to work with the Government to ensure that we can bring forward robust legislation that will not be open to interpretation and it will not be open to legal challenge. Guramahagat.